This episode is based solely on sworn testimony, court transcripts, and statements made in open court. All opinions expressed are commentary on those public records. Nothing in this episode should be taken as statement of fact about any individual's character or conduct outside the information contained in those documents. All persons are presumed innocent of wrongdoing unless proven otherwise in a court of law. In the Upper Peninsula of Michigan, trust isn't just a virtue, it's a survival skill. Winters are long, communities are small, and reputations last longer than the snowbanks. People remember who stood by them, who helped them, who told them the truth, and they remember who didn't. This is Delta Deep Dive. Now let's dive a little deeper. For more than 50 years, the Larson financial practice in Marquette was built on that kind of trust. A small office with a big reputation, steady, reliable, woven into the lives of hundreds of families. When Larry Larson retired, he didn't just sell a business, he passed on a legacy. $477 million book of business, built on one handshake at a time. He sold the business to Jordan Beck, a young investor, born and raised in the Upper Peninsula, who Larry Larson knew he could trust. Beck carried on the tradition faithfully. He was transparent, honest with clients. He helped people. Importantly, Beck hired a first-rate team of people to work with him. His star employee and future nightmare was a man named Justin LePage. And here's the part most people never hear. When Beck bought the Larson practice, Justin LePage wasn't part of it. He wasn't a partner. He wasn't an owner. He wasn't someone Beck had built the business with. He was an employee of the old firm. Beck brought him in later. He offered him a chance to be more than an employee. He offered him a 49% stake in the Marquette office. He offered him a path to ownership. He offered him trust. And that decision, that act of generosity, is the hinge on which this entire story turns. For years, the partnership worked. Beck oversaw multiple offices across the UP. Justin ran the Marquette branch, day to day. Clients saw him as the face of the office. And Beck trusted him enough to split profits 51-49. Trusted him enough to let him manage the largest branch of the entire operation. Trusted him enough to believe him when he said he'd never walk away without talking first. According to sworn testimony, LePage's compensation from the Marquette branch was estimated at roughly $1.2 million per year, a figure that underscored just how much trust and responsibility Beck had placed in him. But trust can be a dangerous currency. In late August 2025, Beck received a text from a former advisor named Ted. The message was simple. "Are you guys making a big move?" Beck had no idea what he meant. When he called Ted, told him he'd heard at a dinner party that someone from the Marquette office, someone close to Justin, was talking about going to Schwab. Beck hung up and immediately called Justin. According to Beck's sworn testimony, Justin denied everything. He said he wasn't leaving. He said he'd never do that. He said if they ever parted ways, they'd sit down with lawyers and do it the right way. Beck even told him, "Just don't do it in the middle of the night." Justin reassured him. He said he would never do that to him. But while Beck was being reassured, something else was happening behind the scenes. According to the evidence presented in court, Justin had already begun preparing his exit. Quietly, methodically, and with precision. He purchased the building next door to the Ameriprise office. He renovated it. He filmed promotional videos for his new firm months before resigning. He created a website. He lined up the entire staff, all 6 employees. He allegedly converted client portfolios into easily transferable exchange-traded funds. He allegedly checked the Ameriprise voicemail after resigning. He allegedly marked the Hinterland's Google listing as permanently closed. He allegedly made house calls to clients with misleading information, and he kept all of it hidden from the man who trusted him most. Then came December 1st, the day everything detonated. Beck flew into Michigan expecting a normal workday. He walked into the Marquette office, the office he owned, the office he paid millions to acquire, and found it empty. Not quiet. Empty. The lights were off. The phones were dead. The staff was gone. The office was shut down, and next door in a fully renovated building, a new financial firm was already open for business. Beck didn't know the office was closed. He didn't know the staff had resigned. He didn't know the clients were already being contacted. He didn't know that Justin had been preparing this for months. He found out the same way the public did, by walking into an empty building. That moment, that walk into silence, became the heart of the courtroom battle that followed. Because what happened next wasn't just a business dispute, it was a legal emergency. Clients began receiving calls, house visits, messages, and this is where the story turns from betrayal to deception. According to sworn affidavits, clients were told, "Your accounts are just being moved over. We're the same team. We just moved next door. The Ameriprise office is closed. Jordan isn't here anymore. Larry Larson supports this move." But none of that was true. The office wasn't closed. The team hadn't moved. Jordan was still the owner, and Larry Larson signed an affidavit saying he did not support the move. Clients were told they were simply being moved over, as if this were a routine administrative change, not a mass extraction of assets from a firm whose owner had no idea what was happening. And every day that passed, more clients, many of them elderly, many of them Larson's longtime clients, were being pulled away. According to Beck's filings, more than $100 million in assets moved in the first 16 days, more every day. In court, Beck's attorney described it as a siphoning operation, a funnel, a pipeline of assets flowing from the Ameriprise practice into Justin's new firm, and the judge listened. He listened to the testimony, he listened to the affidavits, he listened to the timeline, he listened to the defense argue the clients could choose where to go. He listened to the defense argue that this was all allowed under FINRA protocol. And then he said it. He said the way Justin left wasn't just wrong, it was sneaky. The judge called it a Pearl Harbor job. A surprise attack carried out after months of reassurance, months of planning, months of pretending everything was fine. The judge said that if Beck's affidavit was credible, then Justin knew exactly what the proper way to leave was. He knew he should sit down with lawyers. He knew he should negotiate. He knew they should do it the right way. But instead, he chose the middle of the night. And then the judge raised something unexpected, something that hadn't come from filings, but from testimony in the room. He said there was evidence that Justin had tried to convince Beck to buy a new airplane, a major purchase, one that would have drained Beck's available capital. The judge noted that if that testimony was true, it suggested something deeper than a messy breakup. It suggested strategy, because if Beck had bought that plane, he wouldn't have had the liquidity to mount a strong legal response. He wouldn't have been able to hire counsel, file emergency motions, or fight a sudden mass extraction of clients. The judge said that if this allegation held up, it pointed to an effort to weaken Beck financially before the December 1st exit, a move that, in the court's words, would be deeply troubling. It was the kind of detail that made the courtroom go still, not just planning, not just secrecy, but an attempt, if true, to disarm the other side before the attack. Then the judge turned to the funneling. He said the evidence suggested that Justin had been preparing client accounts for transfer long before December 1st, that he had allegedly converted portfolios into exchange-traded funds, making them easier to move, that he had allegedly been checking Ameriprise voicemail after resigning, that he had allegedly made misleading statements to clients, that he had allegedly used the trust built under the Hinterlands brand to redirect clients to his new firm. The judge said these actions, if true, were not just competitive, they were deceptive, they were harmful, they were a breach of fiduciary duty, and he granted the temporary restraining order. For 14 days, Justin was barred from contacting any client he had serviced at Hinterlands. He could not call them. He could not solicit them. He could not induce them to leave. If clients came to him voluntarily, that was allowed, but he could not pursue them. The judge made it clear. This wasn't about stopping competition. This was about stopping deception. He said the evidence showed a pattern of secret planning, misleading statements, and a breach of trust between partners. He said the court would not reward a Pearl Harbor-style exit. And as the hearing ended, the judge reminded both sides that the case would soon move to FINRA arbitration. But until then, his order stood. A business partnership shattered. A financial office emptied overnight. A judge calling out betrayal in open court. And a community of clients caught in the middle. This case isn't over, but the record, the sworn testimony, the affidavits, the judge's own words, paints a picture of a dramatic, calculated exit that left one partner blindsided and a courtroom stunned. And it all began with a man walking into an office he didn't know was already gone. This has been Delta Deep Dive, and that was Betrayal in the Night. Follow for more.